When the Supreme Court made what they call advisory opinions, if I even go to the reasons why and how they got there were different options proposed of bringing the operations of military justice within the context of the judicial functioning in Uganda. One of the proposals made, especially through the lead judgment of the Honorable the Chief Justice, was we could create a division in the High Court, just like we have a division in the High Court that handles corruption and other issues. And the reason was to detach the military from the administration of justice, which is a specialized function, not just on technical grounds, but even under the doctrine of separation of powers. And I missed the Attorney General yesterday. He would have explained to me why, of all the options suggested by the Supreme Court, they opted for what we see here. That's why the Honorable Alternate Chair is talking about, stating what he has just stated. 5 years, 7 years, 3 years, it could even be 10 years. As long as somebody you're calling a judicial or quasi-judicial officer has prospects of redeployment, promotion, punishment, and so on and so forth, you are not creating an independent, impartial court. And to me, that's the crux. It has nothing to do with whether you're trying civilians or military officers in a military court. The nature of the establishment of the military cannot guarantee a fair trial. It cannot be an independent court within the description, within the confines of the Constitution. You cannot talk about security of tenure and you're talking about 5, 7, or even 10 years. Why not 20? The moment the person you're choosing as a judge, quote unquote, is a military officer expected to abide by a certain code, Honorable Chair and Honorable Members, you're wasting time. You are not going to create a court that conforms to the tenets of a fair trial before an impartial and independent tribunal or court, by whatever description. And I want to agree with the MP from Bugweri, my immediate neighbor. I've forgotten his name. The beauty is that under the rules we refer to members by their constituencies. Yeah, like Busiro, which some people who didn't go to school cannot pronounce. Mr. Chairman, the discussion must go back and I wanted to agree with him to the extent whether somebody is a soldier or not, he's entitled to the same privileges once appearing before a court. It must be independent. The second element relates to this thing of aiding and abetting. And I want to relate it to where they said someone is in illegal possession. Legal versus illegal. I mean, I have a licensed gun and someone has just stolen a gun, how we should handle them. One, this aiding and abetting is a matter that must equally be decided independently. Here you are, you're having somebody, a prosecutor in the army, who decides whether to charge me with that offense. He decides, and he's not independent. You have an office of DPP, and this was touched again by the court, a Director of Public Prosecutions, whose function, among others, is to avoid abuse of judicial process. But supposing I have, I am NUP, and this particular officer is inclined to think I must support NRM, as you know how they treat themselves. They feel they are part of the NRM. This officer will charge me with aiding and abetting. Those are ingredients to be proved. Now, the person who is preferring the charge is not independent, like we created office of DPP, presumably independent. Two, the court before which I am appearing is equally not independent. Expect deployment, supposing he makes a wrong judgment and is posted in Karamoja. So, the Karamoja I'm referring to is where they are saying go into cattle rustling, and I do not want to impute bad motives on what happens in Karamoja there when you are deployed there. So, my view, Chairman, is as we pursue the area of discussion with the government, which I'm amenable to, we must also interrogate why we cannot go for the other options suggested by the Supreme Court, as opposed to this one, because this one is going to take us back into the same conundrum. I want to thank you, sir.
The High Command is an organ of the Defense Forces and it's provided for in the law. And that's why it's the highest decision-making body in the army, so that should be quite clear. I do agree that there is a legitimate concern, which was slightly beyond the scope of my memo, regarding the separation of the investigative and prosecutorial roles within a justice system. In the military, these two ultimately are fused. And when a person is charged, it becomes very difficult to separate the members of the system who are carrying out the investigation, the members of the system who are prosecuting this individual, and the members of the system who are now performing a judicial role. And that is why it's an area that requires careful thought. But the overall theme, Mr. Chair, which I need to explain, is that all professional armies world over do have court martials. Okay? It's not a unique Ugandan situation. And the purpose why the military system must have a court martial is partly because even these normal offenses like murder may occasionally need input of people who have an experience of combat. For instance, if a soldier is armed and is attacked and kills 20 people, for us the civilians, we may say, no, he has killed 20 people. That's a murder, he has killed them. He must be charged. But the colleagues may say, no, this was self-defense. These people were going to kill him and he had the option to kill them first. So there are contexts like that. For instance, I had a view about a police officer who was killed in a mob in Uganda, and I felt he should have killed more of those people first before he was killed. But you see, those are operational issues. And therefore, there are these crimes which may be committed in the context of, which require some operational insight on what goes on at a front line, in a combat zone. And that is why all modern armies have a level of military courts. Why ours here is becoming controversial is because of, one, this idea of trying to bring in civilians all the time. That's the biggest problem. Then secondly, setting it up as a rival court to the civilian system. It's not, instead of supplementing, it appears to be suppressing the civilian system. Those two are the unique Ugandan issues which we need to look at. One of the honorable members asked why I'm giving the bill 80%. This bill, as I indicated, is way more than this clause about civilians and the military justice system. And like I said in my memo, a large part of it about the welfare of the defense forces is long overdue. I have done work for representing members of the armed forces who are injured, who are amputated, and they are in Mubende, in the hospital, and that is all. And they don't know how to move on with the rest of their lives. So I think it would be very unfair for this bill to get a bad name because of these 4 or 5 clauses which we can work on and which this committee can work on and or remove. The idea about how a military court operates is only getting controversial because of that idea of when you bring in civilians. For us civilians, we look at things, of course, also with the civilian eyes. And the standard of justice we expect and the kind of offenses that are going to be tried makes it very, very critical to comply with a very, very, very stringent standard. That is why in my memo, when I point out, someone gave an example of the offense of murder, you will note, Mr. Chair, that in my memo, I'm insisting that the right of appeal that exists for ordinary murder trials at the High Court, which is 2 appeals, Court of Appeal and the Supreme Court, should be replicated. Because if somebody is tried for murder before the General Court Martial, the bill says they have only one right of appeal to the Court of Appeal, and it closes there. That is obviously not fair. Where will be equality before the law will be coming into play? Because both people are charged with murder. It can't be that a civilian charged with murder should have 2 appeals, and a soldier charged with murder can only have a right to 1 appeal. It simply creates a system that is not fair. On the subject of explosives, chemicals, and pistols, as I indicated, they are simply listed in a blanket manner as being ordinary monopoly of the defense forces. It is not indicated anywhere in the bill whether there is any other individual who could access them without becoming subject to military law. And therefore that leaves room for interpretation, which could be problematic. That applies to explosives generally, it applies to chemicals, and it applies to small firearms, pistols, and that category. The example I gave was if somebody has a firearm and his or her license expires, they are technically holding it now contrary to the law. So if they use it to commit an offense, according to the bill, they will be under section, under clause 117A, will be triggered. They will become subject to military law. And I think that is quite beyond what might be what the drafters could be having in mind. And that's why I insist about the need to cross-reference the Firearms Act, this law on explosives, and this other one on prohibition of chemicals and toxic chemicals. Because it may not be an issue now, but as I know, honorable members here know this far better than the rest of us, you legislate for the future. You don't only think about the current challenges that we have. We may have more difficult challenges in 5 years, 10 years, over some of these provisions.